Hello and welcome to this program. Today's program is on international humanitarian law, and this program is a part of our certificate in international humanitarian law. This program is offered by School of Law, and this is a 6-month program. And the student has the option to complete it within 2 years as per the university rules. This program covers the basic concepts of international humanitarian law. It's what is international humanitarian law and how it evolved, the main principles, the main instruments, and its application in the domestic area in the country, in India, and role of various stakeholders such as mass media, educational institutions, students, etc. And this program also covers the position of humanitarian law in the ancient systems, Hindu system, Islamic system, Buddhist, Christianity, etc. And it covers the South Asian countries, SAARC countries mainly, what is the position of international humanitarian law there, how many treaties they have ratified, and how the international law is being observed in those countries, what are the cases of the violation of humanitarian law. So these things have been covered in this program. So today I will talk about the meaning and sources of international humanitarian law. So if you see in general terms, what is international humanitarian law? International humanitarian law is a branch of international law containing a set of rules which seek for humanitarian reasons, means, and mainly if you break down the definition, it limits the use of warfare, it limits the hostilities, it in a way you can say puts restrictions on the use of weapons and use of forces use of forces on the people who are no longer participating in the hostilities, who are no longer participating in the people who are not participating in the hostilities. So these are the basic things which we have to understand. So the main principles, the basic principles of international humanitarian law are distinction between civilian and combatants. So it makes a distinction between civilians who are not the part of armed forces and the combatants who are participating in the warfare. And it also prohibits to the attack on those who are not non-combatant, who are not participating in the war. Prohibition to the infliction on the suffering. So it prohibits the suffering on the people who are not participating in the hostilities. Principle of necessity, that is, the force should be used wherever it is required, and the principle of proportionality, that is, the forces should be used in proportion to the hostilities. Suppose there is an attack on the forces of suppose there is an attack on the country. Suppose it's a minor attack, some infiltration activities or so on. In that case, full-fledged war cannot be resorted to. So it should be in proportion to the hostilities. The force to be used should be in proportion to the hostilities imposed on by the other party. So when the international humanitarian law applies, so international humanitarian law, as we have understood, in the situations of an armed conflict. Armed conflict can be international or non-international. An international armed conflict means where the two states are fighting, two states are indulged in hostilities, and non-international armed conflicts are those situations where there is an organized resistance rebellion group on the one side and a regular government on the other side, and these are fighting with each other. So it applies to international as well as non-international armed conflicts. So international law is basically a branch of international law. So the sources which are of international law are necessarily the sources of international humanitarian law. So the mainly the sources are customs. Even today, international law is governed by the custom on those areas which are not codified. Although most part of the international humanitarian law is now codified, new customs can emerge. New situations arises, and when there is no specific provision in international treaties and conventions, then the matter is governed by the practices, and these practices later crystallize into customs. Similarly, general principles of law recognized by civilized states, is because international law is developed from domestic law, from municipal law, from the laws of the countries. So the principles which are recognized by international by most of the nations in their municipal laws are also the sources of international law. And subsidiary sources are the judicial decisions, the decisions of the International Court of Justice and other bodies, and teachings of the highly qualified publicists. These are the subsidiary sources. So in international law, the rule of precedence which is followed in domestic law, in the law of the country, is not followed in strict sense. So now we come to the main sources of international humanitarian law. So basically nowadays there are 4 conventions of 1948, which was adopted after Second World War. And there is a Hague system also. There are a number of conventions which were adopted in 1899 and 1907 and thereafter. But most of the things are now being covered by 4 convention optional protocols and later treaties and conventions. So we will briefly discuss the 4 Geneva Conventions which was adopted in 1948. So the Geneva Convention for the amelioration of the conditions of wounded and sick in armed conflict in the field. Yeah, 1949, and this is also called the Geneva Convention 1 or the first Geneva Convention. And the second one is the Geneva Convention for the amelioration of the wounded, sick and shipwrecked members of the armed forces at sea. This was also adopted in 1949, and this is all called the second Geneva Convention. And the third Geneva Convention is the Geneva Convention relative to the treatment of prisoners of war, 1949. This is known as the third Geneva Convention. And the Geneva Convention relative to the protection of civilian persons, this is known as the fourth Geneva Convention, and it was also adopted in 1949. And thereafter there are additional protocols, 2 additional protocols which was adopted in 1977. Protocol 1 is related to, it was adopted in the 12th August of 1977, and the first protocol was related to the international armed conflict, and second protocol deals with the non-international armed conflict. So these are the main instruments which deal with, and there is also a third protocol that was adopted in 2005, and the third protocol recognizes that that crescent as one of the symbols, like red cross and red crystal. Red crystal it was adopted as one of the symbols of one of the symbols of red cross, like red cross, red crescent. The symbols are used for denoting that the organization which uses these symbols are involved in establishing peace and providing relief to the victims of armed conflict. There are other conventions and treaties also which we will briefly discuss. But these 4 conventions which we have talked about, and additional protocols, are the main sources of international law nowadays. The first convention, that is convention relating to land warfare. These conventions mainly deals with the sick and wounded persons in the land, and it mainly covers the medical personnel, facilities, and equipments, and it covers the wounded and sick civilian support personnel accompanying the armed forces, because these persons should not be attacked. Military chaplains who are part of the forces who provide the religious type of services. Civilians who spontaneously take up arms to repel an invasion. The second convention, the second Geneva Convention, that is the convention related to sea warfare. It mainly covers. It was adopted in 1949, and this convention provides protection to like the first Geneva Convention, but it relates to the sea warfare. The convention, when the armed conflict takes place in the sea. So, and the people who suffer due to shipwreck, due to the damage of the ship. It contains 63 articles, and it mainly covers the armed members who are wounded, sick or shipwrecked, as I told you, hospital ships and medical personnel, civilian who accompany the armed forces, similarly, the third Geneva Convention, that is a convention related to the prisoners of war, and this convention mainly covers the protection which should be available to the prisoners of war, because prisoners of war are people who become captive by the armed forces, and these people are fighting for their country or their forces. So when they are apprehended by the opposite party, by the rebel party, they should be treated humanly. The information which can be sought from them should be related to their badge, their designation, etc. Secret information should not be asked from them, and they should be provided the basic amenities: food, clothing, medical necessity, medical facilities, or etc. They should be treated humanly. Adequate or they should be housed in safe conditions, humane conditions, where the rules of sanitation are followed, clean environment, and they should receive sufficient food, clothing and medical care, and also their religious practices should be respected. They should be allowed to follow their religion, to perform their religious worships, etc. And their recreation facilities should also be provided to them, and also they should not be compelled to fight against their country, against to which they belong. whether it is another state or another rebellious group. So these are the main protection which are available to civil prisoners of war. Similarly, the fourth convention, that is, which is related to civilian population, and this provides a protection to civilians who are not participating in the armed conflicts. Their institutions such as hospitals, schools, colleges, marketplaces, recreational places, and other places which are not the part of hostilities should be protected. And when the another party occupies that the place, their customs, their traditions should be respected. They should be treated humanly. They should not be subjected to any kind of torture or any kind of inhuman treatment. And they should be protected from murder, torture, or brutality, and they should not be subjected to any discrimination on the basis of race, nationality, religion, or political opinion. So these are the main provisions relating to these conventions. Now, and optional protocols, as I told you, first protocol, and the protocols are basically to expand the provisions of the conventions. These clarify the provisions of the convention and provide a kind of better protection. So because we have limited time, so the first protocol deals with the international armed conflict, as I told you, and another second convention of 1977 deals with the non-international armed conflict. So non-international conflict is a problematic area. Many of the countries have not ratified it, and it depends on the declaration that there is a non-international armed conflict. There is a organized resistance force, but generally states refrain from recognizing any party as rebellious force. They consider it as law and order problem. So there are other conventions which you can see on the screens, other conventions and treaties. These are basically deal with biological weapons, bacterial weapons, use of nuclear weapons, etc. We in this session we try to give you a basic idea of international law. What is international humanitarian law? Yes, yeah, and as I told you, the international law basically limits the use of forces. Ideally, the situation should be that there should not be any use of force. States should settle their disputes by peaceful means, and United Nations Charter also says it in Article 2. But because this is the ideal situation, and we have not reached that situation where the disputes are settled by peaceful means. Armed conflicts takes place. So it was decided that, well, if we cannot prevent armed conflict, we should at least try to minimize the hostilities during armed conflict as far as possible. So this is the objectives of international humanitarian law. So with this we wind up. Thank you very much.